You're live.
Welcome, folks. This is House Corrections and Institutions Committee. It's Thursday, April 16th, and it's our morning meeting, 9:30. We are still working on S-193, and we have with us the Vermont Network that is here to give us their S-193. So Charlie,
Terrific.
identify yourself for the record.
Good morning. I'm Charlie Glisserman. I'm the policy director at the Vermont Network Against Domestic and Sexual Violence, and appreciate the opportunity to share some recommendations on strengthening victims' rights within S-193. I submitted written testimony, which Tate posted. Thank you, Tate. That has a few language suggestions within it in case that's helpful for following along. In House Judiciary earlier this session, we presented a bill H627, which concerned victims' rights in forensic cases a bit more broadly than the forensic facility bill. And the committee really expressed interest in further consideration of these issues in the context of a new forensic system. So as S-193 kind of started to take shape and headed over to the House, we reviewed it with an eye towards how do we strengthen opportunities for victims' safety, justice, and healing within this system, and appreciate your consideration of a few items that rose to the top for us.
Are they looking at that bill again to incorporate it into their?
So we have language recommendations. Some are like informed by that bill. Some language is pulled directly from it. And some is informed really not by the bill language, but by the testimony on the bill that kind of helped us take shape of what is really operationalized within victims' rights in forensic cases. So right now, S-193 as passed by the Senate includes some language on page 10. It's lines 7 through 9 that ensure a victim's right to be heard at any hearing under Section 3. So that's page 10, lines 7 through 9. Section 3 governs the procedures for individuals found not guilty by reason of insanity and their interactions with the forensic
Hold on
facility.
just a second, Charlie. We've got different terms of it.
Because that's not the right.
Oh, okay. So I think we're looking lines 5 through 7, right?
Yeah, I
Section
think
G,
so.
Section G.
Lines
I
5
will-
through 7.
You actually get
It's 5
7,
through
8,
7,
9.
yeah. Okay.
Any hearing under this section?
Yes.
Okay, got it.
So we're under not
Different line
guilty by
numbers.
reason of insanity.
Correct.
Right.
Perfect. Thank you. Teamwork. We can all make it happen. So this language provides victims an opportunity to speak directly to the court. This is vital in supporting victims' healing. It restores a measure of agency within the criminal legal system. It also helps ensure that decisions are made with the full awareness of the harm the victim experienced. We have a few recommendations to strengthen that right that already exists within the bill. We're certainly speaking to House Judiciary Committee about this language as well, but for context, I thought it might be helpful to just quickly run through it with you all. So our first suggestion is to mirror language that exists currently in Title 13 around sentencing proceedings and plea hearings that details how a victim will be given the opportunity to be heard in court. So it specifies that the court will ask if the victim is present and whether they would like to be heard. And if they are not present, the court will ask if the victim has expressed either orally or in writing their views. So just make it really clear both to the court and to victims, like really what this process of being heard would look like. Our second recommendation also comes from that section in Title 13 that just specifies that a victim has the right to be given advance notice by the prosecutor's office of the date of the proceedings, so that they have that meaningful opportunity to be at that hearing, be notified in advance. Our third suggestion is informed by some of that testimony we heard earlier this year in House Judiciary on victims' rights in forensic cases. And this suggestion states that if the victim is not provided with notice of the hearing, as required by law that the hearing will be continued, And this just provides an opportunity for a victim to be heard. We know that things can fall through the cracks, and we want to make sure that a victim's right to be heard is prioritized and ensured within the hearing process. Additionally, as you noted, Chair, Section 3 is specifically governing procedures around individuals found not guilty by reason of insanity. It does not govern procedures around individuals found not competent to stand trial. In conversations with stakeholders about the bill, it was actually our understanding that it was the intention for this right to be heard to apply to both types of cases, but right now it only applies in one. So we would recommend additional language to clarify that the right to be heard and related procedures applies in both cases.
I'm sorry, did you give that to judiciary?
We did.
Okay.
So are they incorporate, Troy said, did you give that to judiciary? Is judiciary incorporating anything that you've just mentioned in G for the not guilty by reason of insanity?
So I testified on these changes, I think on Tuesday. And it's my understanding that they will not be considered in the next draft, but in the subsequent draft, they're hoping to incorporate some of these changes.
And is it specific where I mean, maybe this is something for you, Chair. Do you know where these suggestions should be added just after G, in G?
That's up to council.
Okay.
Village council.
Just wondering. All right,
Village
thanks.
council deals with
May I ask why they have to wait until the subsequent version?
I do not know.
It may be something that they're doing in steps. I don't know. Or they started working on this draft first.
Already had it?
There'll be many more drafts.
Yeah.
Perfect. Well,
No, I was just agreeing with you.
the second set of recommendations that we have, I think are more within the corrections and institution space, and are specific to victim notification when a person is in a forensic facility. So as you all know, access to timely information about significant changes in an individual's status, like transfers or discharges, are essential pieces of information so that victims can make informed safety plans. And there are existing statutes that govern forensic cases that outline a victim's right to notification when a person is transferred from a hospital or a secure residential facility to the community on an order of non-hospitalization. In small states like Vermont, we've seen gaps in these notifications that have resulted in victims unexpectedly encountering the person who harmed them at their workplace and in their neighborhood grocery store. And these are experiences that can just be really destabilizing and re-traumatizing for victims. And so when we're thinking about this forensic system, we're thinking about victims' need for consistent, reliable, timely information to preserve their safety, and want to ensure that policies to ensure those rights are effectively realized are considered within the draft. So we request that the committees add language directing within the process of rulemaking, the Commissioner of Corrections in consultation with the Department of Health, DMH, and DALE, to adopt rules on victim notification within S193. We think.
I'm just looking for this on your document.
That's at the end.
It's at the
What
end.
events?
It's the last.
Thank you. Sorry, I'm still catching up.
Okay.
A couple things that we're considering around what these rules might address. What events within a forensic facility would trigger victim notification? What entity would provide that notification and by what methods? How victims will be informed of their right to receive those notifications, and what processes will allow a victim to opt in to notification, opt out of any or all notifications to maximize victim choice. I think these questions may sound familiar.
Here we come again with Vine.
But we see this as a real opportunity to think through some of these questions now and in the context of this facility. That is all I have to share with you today. I really appreciate your time and consideration, and I would be happy to answer any questions. Thank you.
I feel just what,
Well, I'm not going
Yeah,
anywhere.
I know you're not going anywhere. I know this notification thing is so intertwined with the work that we've done with Vine. And Vine is under DOC. And what you're recommending is that they consult as well with DMH and Dale, and all of that. I'm just, we're gonna work with Vine.
And to just be clear, so all of the rulemaking, at least the language in the bill right now, has all rulemaking led by the DOC commissioner in consultation with those entities, and that's why we felt it was appropriate.
Just a quick clarification, it's only because I'm not a lawyer. In your third suggestion down there, the
Mhm.
court shall continue the hearing, that means the court shall push the hearing in advance, so, and not have it that day if the notice wasn't given to the victim. So it just means postpone. Thank you.
Yeah.
Reschedule. Thank you. Just needed clarity.
So you think on your first recommended language changes, that might be included in terms of the process in courts and reaching out to the victims? That might be addressed in the second draft. It's coming out of Judiciary Committee, is your thinking?
That's my understanding. I'm happy to stay in touch on it.
And then for us would be the victim notification piece within the forensic facility. Haley,
Well, not only within the facility, but right, there's
they're outside.
possibility from transferring from hospitalization to a facility, a forensic facility, to non-hospitalization, the community, right? There's a lot of
There's a lot of
potential moments in that transfer, and it could go back and forth, right? Depending on the
But
fluidity
then
of
if they get
competency.
into a hospital setting, it's a whole different world of notification.
Right, because of HIPAA.
It's a HIPAA.
Well, and these are also people who are in need of treatment in a forensic facility. And so I think, I'm not shying away that it in some ways it's a complicated issue. And the reality is that a victim is a
Yeah,
victim.
I'm not arguing that.
Oh,
Yeah,
no,
yeah,
of
yeah.
course. And so just I was going back and forth about what exactly we recommend here. And I do think that procedures around victim notification should be laid out in statute, and also recognize that there are many open questions around how this would work, that we felt that it was best to give these state entities time to think through some of these questions, and we can continue to stay and touch on it through the off session into next year if anything further is needed from our perspective.
I'm wondering, we were gonna send a letter of intent to the victim notification task force folks, just kind of encouraging them to continue to meet. I wonder if this is one issue that we highlight in that letter of intent, that they need to start looking at. Because this is gonna be really complicated. I mean, I'd like to, we're gonna have DMH in tomorrow morning. We're gonna have DOC back. This is something we need to vet a little bit. This is really complicated. It's pretty clear if they're under the custody of DOC and they're in that facility. That one's clear, but it's when they get moved. If they're moved to the state hospital, or even if and they could be moved from the state hospital back to the community, then there's no notification whatsoever that comes from the state hospital.
And there are in existing statute, I included the reference in my written testimony. It's 13 VSA 4822. Does outline victim right to notification within forensic cases. And so there are already some basic standards around what information victims should have access to. I think what we are hoping is for details around how this would be operationalized within this new forensic system. I don't know if Jennifer Pullman has testified on this bill yet in this committee.
No, not here.
But as Great. So, I know she has some really great expertise from past work groups around forensic cases and victim notification. And some of these issues have come up in the past in these work groups. And I think that there have been some consensus recommendations that have come out of those work groups around, in cases where there is the cases that we're talking about, where there is a risk of a life sentence. I think even in those work groups, people were speaking more broadly around cases where there was serious bodily injury or threat of serious bodily injury. That victims should have access to this kind of information to ensure their safety. So I'm sure that she might be willing to speak to that as well.
48 to get there. Let's see what it says. Oh, but it's under the insanity as a defense. Commissioner of Mental Health should give notice of the discharge to the court, the state's attorney. Doesn't say anything about victims.
So, and
4822.
the state's attorneys could also, I think, speak.
An advocate. Oh, okay.
So all of this information,
Notice, yeah.
it flows through DMH to the state's attorneys, who then provide notice to the victims.
You have that right in front of you?
The statute?
Yes, that you're referring to.
You can look it up. So
No, but if she's got it, read it, that'd be helpful.
Sure thing. I'll bring it up right now. The Wi-Fi in this building.
it's very slow.
You should see it in the prisons. Can't see it in the
Or
prisons.
not.
So I'll,
So for the victim notification of the situation, if you've been talking about, should it also, I mean, the statute that you referred to only pertains to those with the insanity defense. Should it also be for the competency restoration?
So, reading from the statute, this subdivision shall apply when a committed person to the care and custody of the Commissioner, Department of Health under this section after being found not guilty by reason of insanity or incompetent to stand trial, provided that the person's criminal case has not been dismissed. So that's the current language.
What section are you in? You're in Title 13.
Title 13, 4822. You are right that the section title says findings in order, it says person with a mental illness.
But it's under, okay, but it's under the chapter.
It is.
Insanity as a defense,
Mhm.
but it's the Commissioner of Mental Health.
So then later in the chapter, so it specifies some of the conditions that would trigger victim notification, at least 10 days prior to discharge from the care and custody of the commissioner or a hospital or secure residential recovery facility to the community on an order of non-hospitalization, at least 10 days prior to the expiration of a commitment order under this section if the commissioner does not seek to continue treatment or at any time that the person elopes from the custody of the commissioner. Then it notes how this notification will be offered so that when the prosecutor, so the state's attorney or the attorney general receives notice under this subdivision, they should provide notice of the action to any victim of the offense who has not opted out of receiving notice. And I'm sure that they can speak more to how this process works in practice.
What's the working process? Thank you.
Of course. Thank you.
So would you recommend that this also pertains to competency? Not just insanity defense?
It's my understanding that it currently applies to both. And so I think, the questions that come to mind when thinking about this forensic facility, is, what entity provides notice? And, from there, what methods? Are there different kinds of information that a victim might have access to if a person is in a forensic facility, versus in other kinds of forensic cases? And just want to ensure that those kinds of questions are considered in the process of designing the system.
And in the process of rulemaking?
Exactly.
I'm not a lawyer either, but when you say considered, didn't you just read law for us? Existing law. So the entities need to be compliant to that to the best of their ability. It's not, we're asking them to do it, they need to do it, right?
I think that is exactly right.
Okay. Just wanted to make sure that as a non-lawyer, I'm hearing what you're saying.
You absolutely are. And, these, the statute on forensic cases is also, the procedures are different than the procedures that are governing this forensic facility. And so just ensuring that any victim notification processes that are unique to that facility are considered in rulemaking and practices around the facility.
That kind of answered it, because this is written for kind of anybody who comes into a forensics facility. Don't care really if they're there for, insanity or, whatever their competency is, just everybody.
And I'm going to show my ignorance here too, but if there's a conflict between this law and HIPAA, the courts have to decide if you take it to court, but how does that work with two conflicting mandates?
These are some really great questions that I think should be considered in rulemaking with the Victim Notification Task Force potentially. I think that they are really, in some ways, they're really simple questions. In some ways, they're complex. These are policy decisions in some ways for the legislature. You all decide what exemptions there are to HIPAA. You all decide what victim notification should be outlined in statute. So there we are.
But under current law, we don't know if there's conflict or which would have precedent over the other. That's what I'm hearing you say.
I think that those are better questions for folks who are really operating in the system in practice, like the prosecutors who are responsible for delivering these notifications.
Thank you.
And their legal team. And their legal team.
Oh, yeah, sure. Interpretation is part of the game.
Just reading. Do you think, Charlie, as this process works through, pass the bill, becomes law, whatever, however the bill looks, should there be check-ins somewhere along the way between now and when the session comes back, when we come back in January?
Specifically on victim notification?
That, but also just, I guess, the context of the bill itself. I mean, we do have rulemaking. The rulemaking starts July 1st of this year. And there is an interim report October 1st of this year to this committee, Judiciary Committee, the respective committees in the Senate. And it lays out what that interim report should consist of.
Mhm.
Should there be more check-ins with the legislature or not while we're off session?
I certainly feel like that is a decision for you all. I see here that this interim report will address the status of an anticipated timeline for the adoption of rules under this act. And so, certainly would appreciate information about rulemaking around victim notification within that. But otherwise, I would entirely defer to you all.
So to clarify, are you saying that you don't have an opinion or you feel it's not your place to have that opinion?
Yeah,
Yeah.
Because the reason I'm asking that is we obviously know that, you're not a legislature, you have a role.
Mhm.
But we want to know what your opinion is, and we don't want you to feel like sharing that opinion means you think you're usurping our role. But we value your opinion.
Yes.
I really appreciate that. I'm really here to speak very specifically to victims' rights procedures within this facility. And so, I think in that context, I think including content on victims' rights within this interim report would be helpful. But I don't have an opinion beyond that.
And specifically notification lands in this room rather than that room.
Right.
Yeah. Let me clarify that, if the facility is under the jurisdiction of DOC, that's the if.
No,
But not at the end.
it is DOC.
They don't have vines.
It's gonna,
That's what I mean.
DOC is in the lead here.
Mhm.
In submitting the written report. In terms of. Yeah. It's on section 7.
And so just to ask it again, I think the answer is yes, but judiciary has all of this already.
Yes.
Okay. Okay.
Anything else? This is helpful. Whoops. Kevin, do you have
Right
something?
there, ask how, when you read the room, did you have any inkling as to whether they were with you or a concern?
It's a dangerous game.
I think
Never know.
you could chat with your colleagues over there and see what they would say.
Fair enough,
The chair has been around.
fair enough.
But all
Thank you
right.
for trying.
Thank you.
That room is hard to read.
They heard testimony on Wednesday, I guess that was yesterday, from Emily Perry, who is a victim of a crime that was in the forensic system that we have right now. And what I have seen from that committee is that they have been very attuned to the voices and needs of victims within this process.
Anything else? Thank you, Charlie.
Thank you very much.
Thank you very much.
We are gonna have time as a committee to discuss where we're headed with this and language changes.
Perfect. Thank you very much.
So let's go off of YouTube for a few minutes. We're waiting for ACLU to come in. Are you ready? It was Jack. Is Jack coming in?
Jack's legal aid.
Legal aid.
Legal aid. Don't get me confused. So let's not go off. So Jordan, are you ready for ACLU? Okay, we're a little ahead of time.
I guess.
I know.
Don't change this.
No.
Welcome, Jordan. If you could also identify yourself with the.
Yes, thank you. Good afternoon, members of House Corrections Institution Committee. Thank you for inviting me to testify on S-193. My name is Jordan Souder, I use he, him pronouns, and I'm a policy advocate for the ACLU of Vermont. And I want to start off by saying that we appreciate the need that Vermont has in establishing a forensic facility. This is an important issue and has been for a while. So we appreciate the time that this committee has taken in listening to testimony on this issue. Having said that, we are deeply concerned about housing the forensic facility under the Department of Corrections. As this committee has heard from the Defender General's office, as well as other key witnesses, it is unconstitutional to incarcerate someone who's been deemed non-competent to stand trial or found not guilty by reason of insanity. Therefore, the function of the forensic facility must be solely for the evaluation and treatment of people involved in the legal system and not akin to a carceral setting. And this is something that S193 appears to consider, as it provides on page 11 of 16, lines 9 through 13, that the forensic facility shall be designed and operated in a manner that supports therapeutic, recovery-oriented, and trauma-informed environment comparable to a community-based residential setting. Prison systems are not, nor have they ever historically been, a therapeutic environment. And on top of that, as this committee is well aware, we've heard from the Department of Corrections themselves testify about some of the issues that they're currently facing. Facilities are operating at well over capacity with neither enough space nor beds, and are experiencing some pretty severe staffing shortages. Under these conditions, and this is just want to highlight that this is especially prevalent in the women's facility, where their current population is at 181 and their capacity is at 177. And that under these conditions, DOC is struggling to provide services to the people already under its custody. And this alone calls into question DOC's capacity to effectively manage a forensic facility that they would be legislatively mandated to run as a therapeutic environment. Now, we also recognize the legislative constraints that other departments like DMH have in being able to operate these facilities themselves, and that DOC, as well as DMH, maintain that they would be able to implement this bill with bolstered resources. But many questions still remain. Questions we should know first before committing to placing the forensic facility in an already strained department, like how much does DOC require, how do they plan to create and maintain a therapeutic environment? Where will it be located? All very important questions when trying to establish a forensic facility. Now, I also understand that the bill includes an interim report section where DOC, in consultation with the other relevant agencies, shall submit a report addressing some of these logistical concerns, at which point, from my understanding, the bill is that the committee could theoretically reevaluate from there. And we're generally supportive of that provision of the bill and think that it should come before committing to putting it under the Department of Corrections, and should be the primary focus of S193, because ultimately it sounds like that the question that we have not answered yet is how would DOC establish and maintain a secure forensic facility as a therapeutic environment? And many concerns have been raised regarding the legality of housing it under DOC. And it seems that the legislature has not thoroughly explored alternative options yet. So we propose that this committee use S193 to create a study into the feasibility of establishing a forensic facility under the Department of Corrections. This would give DOC and its partners time to finalize its proposal, as well as give the legislature time to answer some more of these questions and explore alternative options. So ultimately, we think that if it, with this study, and it is determined that DOC could establish a forensic facility under its supervision while running it in a constitutional manner, then we could proceed that way. But we really should understand the how before committing ourselves to a plan that runs the risk of being harmful and unconstitutional. And based on DOC's testimony, it sounds like they would plan to place eligible individuals from this bill within their already overcrowded prison systems, and that the only thing that seems to be different would be the services that they would provide. So My understanding is that this would be the first time that Vermont is establishing an official forensic facility, something that could potentially be a great benefit to our systems and help ensure public safety. So it's especially important that we're doing everything we can to make sure that we're doing it well and build something that won't potentially end up breaking the very law that we're trying to implement. And that is my testimony. I am available for any questions.
Yeah, thanks so much, Jordan. So it's a constitutional issue, right? Is it fair to say there would probably be a lawsuit on this without saying that, you would have a lawsuit?
So, yeah, my understanding is it's not clear exactly whether placing it under DOC itself would make it unconstitutional, but certainly how it would be applied is what would make it unconstitutional. And the more like a prison system and more mingled it is with our current prison system, the more likely it is to be challenged and likely not survive.
And when would that generally come? Would that be upon passage of the bill? Would it be upon implementation of it? It's trying to get a sense of late timeline here.
So I think sort of going to like how the bill is crafted, and it might not seem unconstitutional on its face, but I think it would be as applied basis. So that's why we suggest trying to determine the feasibility first, so we're not putting ourselves into a box where we're starting to build this thing and then later on it's found to be unconstitutional.
Gotcha, thanks.
It's kind of the same question, but you have more specificity on what would trigger in your minds the constitutionality question. Like, what would that look like? What would the system look like that triggers that? And that's more to help everybody understand so they can move forward and what you would consider to be a better way.
I don't have specifics at this time, but we've communicated with various like constitutional scholars who just hearing that it's under the Department of Corrections alone raises some alarm bells. And therefore is going to, this system and how it's implemented is going to be more heavily scrutinized, I think. But I would recommend reaching out to various constitutional scholars on this. I think we're trying to be in communication with Jared Carter, I believe, from graduate school. Might be a good place to start. Thank you.
Troy and then Brian.
Did you give any consideration to the study that you're proposing as a first step? Did you give any consideration on who should put that study together? Who should facilitate that study?
At this time, we don't have specifics, but we're still discussing it over with our team and happy to submit any recommendations.
That would be great.
This can be.
So it's sort of a multi-parter, but we're talking about doing a forensic facility within the Department of Corrections. There are lots of different ways that could be done. I believe that you've heard the testimony from the Commissioner of Corrections suggesting that by providing therapy within the Department of Corrections are then therapeutic. You've just said, though, I think that merely by having this forensic facility within the Department of Corrections, you're essentially inviting a constitutional lawsuit. And so I guess the question is, are there things that make this sort of approach better, more constitutionally sound, or is it just a non-starter, right? What if it rolled up to somehow the Commissioner of DMH within the Department of Corrections? What if you have a separate, et cetera, et cetera? Is there a way of improving this? Is there a way of making this pass constitutional muster?
So I could see, wanting to go to the point we heard that the therapeutic element is the services that it provides.
Yes.
For starters, one, that's not what the bill states, as I was talking about, how that S-193 says that the forensic facility will be designed and maintained as a therapeutic environment. And so I think it understands that the therapeutic elements are not just in the services it provides, but the environment itself. And there's a lot of research showing how effective various treatments and programs can be within prison systems versus in things like residential settings. Having said that, I think having so much of the authority being under the commissioner for the Department of Corrections doesn't really do the bill any favors in terms of constitutionality. I know that the bill shows that like the commissioner of the Department of Corrections in consultation with agencies. I think having more shared power and responsibility might make it a little bit better. So rather like in consultation with, maybe in partnership, sort of, I think distributing the balance of power, I think might make it a little bit better.
And you would essentially mean formalizing that relationship, because again, we've had a testimony, this notion of informally, they're working hand in glove because they all are under AHS, right?
Right. So having something a little bit more concrete within the bill itself, I think would improve its chances. And I also think that having it like running rather than like the facility itself, but like just a unit within our current systems, and having any sort of intermingling within our current correction facility makes it even more likely to be challenged, I would say.
Right, thanks.
If we pursued using other state facilities to fill our need, how would that impact our constitutional situation?
I'd imagine it would depend on how the other states' facilities are run as well. Whether or not like they're placed under that state's Department of Mental Health or Department of Corrections. So I think it's also sort of as applied basis.
Can we get testimony on constitutional?
We could, wondering if that's more judiciary issues, because they're dealing with constitutional issues all the time. It's kind of not in our lane. So I'm thinking you testified and have judiciary.
I have, yes, and I believe they're also looking for
They're looking
constitutional
at the
scholar.
constitutionality of it. That's really the committee that works on that more than we do. I mean, we can do it, but.
But also if need be, Chair, could we do joint or even just watch their testimony as it happens, for instance?
Yeah, you've already been in there, right?
Yes,
And how long ago was that?
2 days ago.
We could bring that up and watch it on YouTube for that.
But I also mean, if there's a direct, a constitutional portion upcoming,
Right.
maybe we can dial in or whatever.
I'm sorry, go ahead.
Do you know, have they contemplated bringing in Jared?
I don't know if it's been brought to that committee.
Okay.
I was going to specifically ask you about, are you able to define the term comparable to community-based residential treatment? Is that something that you're familiar with, or does that get back to the constitutional question?
Might get back to the constitutional question. I don't have a definition of comparable to community residential treatment center at this time, but just with the plain language, I would imagine like looking at other facilities within the community, seeing how they're run. Yeah, and then that we would want it to be more akin like to that rather than our corrections facilities.
This just occurred to me, and so like so many of my questions are ill formed, but I gather that this is done in other states. A forensic facility does exist within carceral facility. And so have those faced constitutional issues? And we're just talking about the US Constitution, right? Not the Vermont Constitution.
Yes, currently, yeah.
I
And
didn't hear that. US Constitution or?
US.
You
American.
said US Constitution.
So you're concerned about the US Constitution being?
I just wanted to make sure.
Yeah, I believe so. That's where my concerns are. Still looking into Vermont law as well. So I lost track of your question.
Me too. I gather this is happening, has happened elsewhere. Do you know of how the constitutional question is played out elsewhere?
At this time, no, and that's part of the reason I think we're proposing a feasibility study. So we also have, so the committees have time to explore other state jurisdictions and how they've done things. Because right now there's just a lot of unanswered questions in a very complicated area of law with a lot of different directions that it's going, so.
Okay, thanks.
So we need further conversations with House Judiciary just to see how they're doing with this. If they are, and then tailor our language accordingly. We're looking at the spots. And we can talk to our legal counsel as well. Drafting, and that would be more Eric, I think, than Katie. Eric Fitzpatrick. Other questions? Thoughts? Thank you, Jordan. Appreciate it.
I'm not sure if it's an email checking it, but.
Marie?
Ring a ding ding.
Speed dial.
That used to be my mayor, so.
I know. Oh, yeah. I want to get the new draft this year.
Okay, so, but get her in.
Yeah.
Okay, great.
To take.
Oh, yeah.
Are we on or off? What are we doing here?
Now, let's go off until we figure out what's going on with